the NJC goes through a process of provisioning, clearing provisioning for the judges. You've got to have the court halls, the salary, the vehicles, the basic provisions for their operations. They cleared 15. The circular was clear. They nominated 34. Of that 34, all but 11 were sons, daughters, mistresses of particular individuals. In one particular case, the original list was 33. I wrote the letter. I signed it in my name. I was not anonymous, so I can tell the story of what transpired. There were 33 nominees. Then a senior judicial figure who was about to leave the bench put his mistress in there, making them 34. She had not been interviewed. She had not gone through the process. And I wrote to President Buhari, to his credit. He listened and suspended the appointment of all of the people that we objected to. So he cleared the appointment of 11. And then something extraordinary happened. A senior justice of the Supreme Court was retiring and managed to get the NJC to bring back the list of those people who had been suspended. And the people who opposed that list were persuaded not to attend the meeting of the NJC. And this particular senior justice had their child in there, got the list approved, rushed to the president, all of them were appointed. They are now sitting on the bench, including the daughter of Justice Bulkachuwa and Senator Adamu Bulkachuwa. So judicial appointments have been totally captured. Politicians and judges make up and take up the appointments. And members of the NJC, if you give me the list of appointments, I will tell you who put the name in there. All I need is make not more than 3 calls. I will tell you whose candidate is on the list. From where? When you get to that point, to a point where good people, irrespective of where they come from, but suitable candidates can no longer make it to the bench, you know you're in trouble. And that is where we are. But it is not just because suitable candidates can no longer make it to the bench, and politicians now have decided that in order to have a successful political career, you need to carry a judge in your back pocket and in your bedroom. It is that to be able to proceed to anything in the country, judges and politicians decide what happens. So politicians no longer need our votes to become governors and presidents and legislators. They now need to settle judges only. It did not start today. If you want to know the origins, please go and read the Babalaki report. In the Commission of Inquiry into FEDECO, which reported in 1986. And if you don't have it, I can PDF my version. It's a little big. I'll make it available to the bride. But every lawyer interested in a country that works and judicial system that works needs to read the Babalaki report, because that is where the story of judicial corruption in politics was actually fully recorded. And I cite some of it in my written remarks. But it has been on since then. And in my written remarks, when you see it, you can check the footnotes as to some of the stories that have transpired from the Aramia constituency in 1979 elections down to Justice Ebu at the beginning of this millennium. But because this has a long history, we need to be able to reflect the memory. And having reflected that memory, then where are we right now? So this is how I start ending, because the story we have is a story of 2 things, or 3 things, as I said. One is hubris. The people who have captured the political system and captured the judiciary dare you to go to court because they'll tell you, we own the judges. They're in our bedrooms. They're in our houses. We own them. You are not going to get anything. That is the story of hubris. There's also the story of mirth. They laugh at you, knowing that the courts are useless. And why are the courts useless? I don't believe that there is anyone here who does not know the case of Mojeku and Mojeku. And it is taught in family law, gender, human rights of women, constitutional law, and celebrated. Go to court happened to Caroline Mojeku. Caroline Mojeku was a widow. Her husband died in 1962. She started litigating in 1966, before the Nigerian Civil War. The Nigerian Civil War ended in 1970. She was still in court. 1976, 10 years later, she was still in court. 1986, Caroline Mojeku was a widow. 25 years going, she was still in court. 1990 happened. Berlin Wall fell. Caroline Mojeku was in court. 1996, 30 years later, Caroline Mojeku was still in court. She had finished Beijing. 30 years later, Mojeku took 31 years to come to decision. And law teachers teach it without looking at the metrics of decision making. 31 years for a widow. Go to court happened to her. Because let's think about ourselves as the man who died. And think of Caroline Mojeku as our wife. Raise your hand if you would want your wife to litigate for 31 years after you are dead in order to get to your estate for your children. Raise your hand, please. Nobody can contemplate that. Because most widows don't live to 31 years. That is a story of mirth, because we as lawyers argue for access to court. Very few of us argue for exit from court. And access to court is not nearly as important as timely exit from court. And these days, how many years does it take to go to court, to get through high court litigation? If you finish in 10 years, you're lucky. But whatever happens, if you get to the Supreme Court, you're guaranteed to take somewhere between 20 and 25 years. Today. The Supreme Court, as we speak, for those of you who argue before it, is assigning 2009, 2010 cases for hearing. And if you miss your hearing date, you have to wait between 3 and 5 years subsequently. That is if you bribe. If you don't bribe, you join the queue, woe betide you. Now, what happens? Governments are actually appealing to the Supreme Court in order to deny judgment debtors of access to their judgment debt. And I'm not going to go into other things that happen at the Supreme Court, but this one is clear on the face of the record. There's ample evidence to say this is what is happening. Now, in ending, what do we see? As lawyers and as judges, when these things come up, we get defensive. We get defensive because all of these dysfunctions mean filing fees for us. They mean transport fares for us. They mean revenue streams for us. And yet the country is going down and every one of us is suffering. Senior advocates of Nigeria are now looking at their options and some are considering Japa. And that should force us to think afresh. Because if the best of our profession no longer find that the profession itself offers them something, there is a problem. There's a big problem. An enormous problem that has got to force us to think. And this is really the place to comment on what happened at the NJC yesterday on the Bulkachuwa issue. Now, some of you would have seen the statement by the NBA president. I presume most people here have seen it. And a lot of people were clapping and hailing it. That statement is a disgrace. And I will tell you why. The NBA president says that what Senator Bulkachuwa did was despicable, amongst other things. But he also reported that the NJC unequivocally, strongly condemned what he did, and as an impairment of judicial independence and integrity. Now you ask yourself, what exactly did the NJC set out to condemn, if in fact it condemned anything? Number one, the president of the NBA is not the spokesperson of the NJC. He's not the chairman of the NJC. He lacks the standing to tell us what the NJC decided. If the NJC condemned what the Senator Bulkachuwa said, what should happen? It is either the spokesperson for the NJC, Mr. Shojioye, or the spokesperson for the Chief Justice who presided and was present yesterday, because there were appointments. That is Dr. Festus. Number two, the NJC claimed, the NBA president claims that the NJC condemned what Senator Bulkachuwa did. But what did Senator Bulkachuwa do? He used parliamentary privilege to trump matrimonial privilege. But it was privilege, whichever way it was, right? And even if, no matter what position you take, finding out the facts means what? Inviting Senator Bulkachuwa, inviting Justice Bulkachuwa, listening to them, listening to other people, reviewing the material, and making a finding on the evidence. The NJC will not do that because they know if they did it, all of them will go down, or most of them will. So because the NJC is afraid of investing, they told the NBA president to go and issue a cover-up. That is disgusting. That is the despicable thing. That the president of the bar, successor to, used to cover up this kind of thing. All of us should be ashamed. All of us should be ashamed. The NBA cannot lend it. And so what do we have? The NBA president telling us with a flourish, oh, you know what? I am writing to the Inspector General of Police. The statutory body with mandate to investigate this thing is the NJC. No, not statutory body. The constitutional body. And it has abdicated. And our president is giving them cover. And we are clapping. But if the NJC cannot investigate this, how can we talk of judicial integrity and judicial independence? How can we tell people to go to court? And so, I could go on about this. But let me suggest a few things. Because if I go to sit down now, I'll be told you just made noise and what is your suggestion? Not that I actually am heavy on making suggestions to anybody, because we all know what our problems are. Let us not fool ourselves. And when you go to the radiologist does not give you a prescription. They give you your slides and report and tell you to go to a physician. We don't, but let me suggest this. Number one, we've got to unbundle the office of the Chief Justice. You know the interesting thing? NJC and CJN are the same three letters, rearranged. But actually, the CJN is the NJC. He appoints whoever it is that is there, and they take the decisions that the CJN wants. As a senior member of the NJC says, whatever the CJN says in the NJC cannot be questioned. This is the practice and the doctrine of the NJC. And the NJC is a lot of bodies in one. And the CJN's office is too many jobs in one. Presiding Officer, Supreme Court, Chief Justice of Nigeria, Chairman FJSC, Chairman NJC, Chairman Legal Practitioners Privileges Committee, Member National Council. I could go on. No one person should have all these accretion of power. The CJN was supposed to be a primus inter pares. There is no inter pares anymore. The CJN owns the Supreme Court. So if you read Faces, Cases, and Places, the autobiography of Chief Justice Fatai Williams, or read the autobiography of Udodoma, and compare with what transpires in our courts today, there is no comparison. The Chief Justice, and why is that so? Justices are ill. They need money to travel. You have to go and beg the chief. Justices need accommodation. You need internet connection. You have to go and beg the chief. If you need someone, your friend, to become senior advocate, you beg the chief. And so the chief is now doling out patronage. He's no longer interested in administration of justice. We need to unbundle that office and make it a lot more accountable. Secondly, unbundle the NJC, make it a lot more accountable. But thirdly, we need to address perverse jurisprudence that has got us here. And that perverse jurisprudence is perverse jurisprudence on judicial accountability, perverse jurisprudence on electoral accountability, because the two go together. The Nganjiwa judgment has done us tremendous harm. And you see Justice Yunusa, who has been recalled, sitting in Kano and deciding on Abia State. And you see, when you write a petition, I don't know the number of petitions I've written against judges. The NJC will tell you it can be corrected on appeal, so we cannot do anything about it. But when a judge who is sitting in Kano decides ex parte, without hearing affected parties and necessary parties on issues as extensive as this, and you tell me that can be corrected on appeal, there is something wrong. Because the judge did this willfully, and almost certainly something passed. But the NJC will abdicate and tell you, you will not be able to, we cannot do anything on this, go on appeal. And the appeals take so long. Meanwhile, the judge is sitting there and collecting more and doing more damage. So that doctrine needs to go, and the Nganjiwa judgment needs to, a judge who has been away for 5 years, what are they doing? And it's not just the Nganjiwa judgment. The Kunle Kalajaye judgment is another problem with an unaccountable bar. A bar that sets different standards for senior lawyers and junior lawyers. If a junior lawyer did what Kunle Kalajaye was set free for at the Supreme Court, the person will be selling Guguru and Epa. But we're here. And the senior advocate is still a senior advocate. Something is wrong with that. There is a fourth issue, which is evident. Judicial appointments have got to change. We need transparency in judicial appointments. In Kenya here, I'm not even going to talk about South Africa because some people say they're not African. But in Kenya, judicial appointments are advertised. Everyone applies. Interviews are open. And selection criteria are clear. The presidents have failed to get their candidates through. Uhuru failed to get his candidates through to appointment. The Chief Justice of Kenya, after the adoption of the 2010 Constitution, was a man who was a prisoner of conscience, detained for a long time, who converted from Christianity to Islam, back to Christianity and back to Islam, and wears an ear stud. But he is straight. Yes, he was a university professor, he worked in the NGO sector, he was a senior counsel, he's a polymath. Willie Mutunga. Willie wears an earring because he was the best candidate. Everyone agreed on the basis of the interview criteria. Why can't we have transparent judicial hires, starting with preferments? If you're having judicial scandals as chief justices, why can't you begin to save the judiciary? The NBA is not interested in doing that. I'm not even going to go into how to rescue the electoral process, because increasingly, how do we, in my view, we can only break this duopoly of politicians and the capture of politicians and judiciary by shifting the burden to INEC to prove that their elections comply with the Electoral Act before results are announced. For a single constituency national election as the presidency, in my view, what needs to happen is you set up your election petition tribunal before the elections. INEC should go to them and prove minimal compliance with the requirements before burden shifts. So the court certifies, as they do in the civil law systems, the court certifies that substantial compliance has occurred. You then shift the burden. If you want to set that aside, do so. And finally, returning to where we started with this. You see a thief, you call them my lord. You see a rapist, you call them pastor. You see a pervert, and they are NGO defender. That needs to change, because it is the social approbation that we all provide to those who destroy our society that makes them go further. And that is the example of Ikeja Bar that we've got to take forth into the country. This example of honoring the right kind of people needs to go forth and be socialized in Nigeria. We need also to honor the right judges, because there are still judges, as difficult as it may be to believe, there are still judges who are striving to do the right things. most of you who I go to court here will know the minority, but they exist. Why can't we find them and honor them in some ways? In ways that will not corrupt them, in ways that will inspire others, in ways that will say you are the right kind of person. And maybe when we mix these issues, reprobation and approbation, incentive and condemnation, recognition and the right kind of criticism, maybe mix it with structural and legislative and institutional and doctrinal reform, maybe we'll begin to make some progress. As I said, no one has a monopoly. And I put forward some ideas here. My hope is that those who are more experienced than I am, and the people on this panel are much more experienced than I am, and much brighter and informed than I am, will take this further.